And we're off. 2 neighbors, 1 gate, and enough bad blood to fuel a courtroom drama. Watch closely. This isn't just about fences. It's about pride, power, and the letter of the law.
Colani versus Smith. Counsel, state your appearances.
General Barker, here on behalf of the plaintiff, Susan Colani.
Written for defense, Your Honor.
All right. And where are we? I received photographs, I believe, by Mr. Friedman that were sent in.
I just received these just before court. I've given a copy of these to Mr. Friedman.
Okay. Is there going to be a dispute or?
There is a dispute.
Okay. And what's the dispute?
Well, Your Honor, I will agree that the defendant technically complied with the court order, but
The legal knife fight begins. Colani's attorney calls out Smith's technical compliance, removing fence slats but leaving the chain link gate that still blocks access. This exposes a critical legal rift. Courts demand exact compliance, but judges hate loophole exploiters. Smith had 45 days to re-engineer, 108, but did nothing. Now the judge faces a nightmare: punish literal obedience? Or reward shady tactics? Watch his frustration build. This gate wasn't just physical obstruction, it was a middle finger to the court's authority.
certainly not the spirit of the court order. All right. In March 27th, they asked for additional time, 45 days, so they could re-engineer the gate. Okay. And nothing was done about re-engineering the gate. So when they took out 15 feet, we did not know there was a chain link fence on the other side. They did take out the 10 slats, but the purpose was, from the beginning of this case, was to restore access that existed for 90 years at least, or at least most of the access to the backyard. So if you leave that fence, that chain link that you see there, it defeats the reason for taking out the 20 feet that was ordered by the court.
No, it doesn't.
Well, it's right in the middle.
This is where judges lose patience. Courts don't like being played with technical obedience. Imagine being told to clean your room and you shove everything under the bed. Yeah, that energy.
Of what would be the access if that were removed.
That's his gate.
What? I know. That's the gate.
Yes, but it's within the 20 feet that was supposed to be removed. See the black mark he did take out?
I see the black mark.
That's where the fence, the 10 sections were.
Hold on. The real issue was access to the back of the property.
Unimpeded access to the backyard, yes.
Right. So the location of the privacy fence, the wooden fence, may have impeded that. I then ordered a specific amount taken out so that that was not an issue. How does that chain link fence impede?
It was, that chain link fence was behind the 10 boards that were ordered to be removed.
I just have to say, it's not a chain link fence. It goes across Mr. Smith's driveway. It's his gate.
I know. I
They were given 45 days to re-engineer that.
Okay, so hold on. What you're really complaining about is a pole.
Yes, in the sense that if that post and the gate stays where it is, then you still have to maneuver around it. Whereas
Maneuver around it to do what?
to get into the backyard.
Oh, but
No, that's,
Look at my-
get into the backyard with what? What are you driving into the backyard?
Okay, I have to, why did we remove 20 feet if,
Because the wooden fence came up on that one side so close to the house. I mean, that pole is so far back that it doesn't, I mean, at some point, any vehicle going in at some point has to turn. And when I was looking at it and when I went out there, the turn.
Notice how the judge zeroes in on the real issue. Access. Not the slats, not the wood, not the drama. Just, can you actually get into the backyard? It's a surgical legal focus.
Was going to be the problem because it was almost, when the fence was up, it was almost like you were going into a tunnel. So turning, getting past Mr. Colani's house is, hang on a quick second. Okay. Turning past Mr. Colani's home would potentially be a tight fit. This is not.
It's not a tight.
Game changer moment. Smith's attorney proves access isn't blocked by parking a 5,000-pound SUV with 3 feet of room on each side, 451. Colani's entire case crumbles. If massive vehicles fit, how is access impeded? This is courtroom jiu-jitsu, using the plaintiff's own photos against them. The judge's skepticism spikes. Why? It doesn't make difference at 11:04. When evidence backfires this hard, cases collapse. But Colani's lawyer won't quit.
Fit. That's a 5,000-pound SUV that's got 3 feet of room on each side.
This is a different photo that I didn't copy to Mr. Friedman, that I will gladly. It is now a gate in the middle of nowhere. Is he going to put something?
Okay.
I mean, is he now going to put chain link?
Well,
I'm not here to decorate his property.
Okay.
I'm just saying
Right.
what the ultimate issue was access to the back. Now, if you're telling me that as it's been laid out, there's no access to the back, then tell me that.
It's not that there's no access, Your Honor. It's that the spirit of removing, had I known when we were here on May 15th that that would still be up, I would have included in the request to have that removed. Your Honor, there is an ongoing problem with Mr. Smith and Mr. Colani. I would like, before that Mr. Colani be allowed to testify as to what's transpired today.
no.
Do what? I mean, transpired was, okay, look, last time we were here, everybody was complaining about how many slats. I remember very clearly because I counted 9, supposed to be 10. Okay, so I take 10 slats out. That's been done.
I also, when we were here, talked about Mr. Smith's harassing and
The drama detonates. Colani accuses Smith of threats and ethnic intimidation, 648, but the judge shuts it down. I don't have a criminal case, 657. Smart move. This is a property hearing, not a drama fest. Notice the attorney's desperation. When losing on law, they pivot to emotion. But judges hate this bait and switch. Smith's lawyer fires back. File a police report. 650. Lesson. Unproven allegations can torch credibility faster than a fence post burns.
today, Mr. Smith.
I don't want to go down that road, Your Honor.
I do, because this is an ongoing dispute.
It's not part of this lawsuit, and I don't want to hear about my client swearing at your client.
Well, then you can file a police report for ethnic intimidation.
What he wants.
He threatened to shoot my client.
Did not. In any event, Your Honor, I don't think
I don't have a criminal case before me.
True.
Let me just say this. And I'll presume that Mr. Colani would get up and say that. What would you have me do?
Remove this, or at least move this gate post back, even with where the 20-foot mark was.
Because that would stop the language or behavior.
Well, actually,
How?
To tell you the truth, Your Honor, I would like to have gone back to my original request consistent.
I'm not going there. I've made my ruling.
I know.
Hold on. You want to bring up something.
Keep that in mind because distractions are coming. Ouch. When the other side uses your own photos to nuke your argument, it's like scoring on your own goal. The SUV demo is genius lawyering, turning evidence into a mic drop moment.
Where allegedly Mr. Smith is yelling at Mr. Colani. And I'm asking a specific question. If I even say that what you said here was said, what do you want me to do? I mean, because at the end, after I hear the testimony, you're going to want me to do something that I would imagine would be directed at stopping that from happening. So if that came up, what would you have me do?
You're absolutely right. There's nothing you could say or do that would stop Mr. Smith from harassing my client. Okay, I will agree with you on that. What I hope to come from today is that you would order that fence post back to equal with the 20-foot mark, because that was the intent, was to open that up. Had I known that fence, the gate was there, back on March 27th, when you first ordered this, they asked for the time so they could re-engineer.
Hold on a second. When we were here the last time, I think I still have the photos. That piece is there. I mean, there's
no new evidence here.
There's really just a post that's there.
All right.
I mean, if he closed that half of the gate, then I'm presuming what you're trying to say is that obstruction is just that post. And I don't see how that obstructs the backyard or access to the backyard.
Had I known that post was not attached to the remaining 5 feet, I would have.
Well, Miss Barton.
I failed.
Well, Miss Barton, if I'm looking at the photos from the last time that we were here, and when I look at those photos, I can certainly tell that post is not attached to the fence.
The photos I had, I can see that half of the gate is visible.
I think that when she's talking about the spirit of this and the spirit of that, I think it is worth mentioning that much earlier on, we talked about the fact that the removal that going too far back was going to impact on that gate and on his privacy, and that the goal was to have the fence, the stockade fence, end at the back of his property so that he could secure that gate, which he can't right now. My contractor literally called me yesterday and said, "Why am I taking out these 5 feet? They're not in the way of anything." And I said, "You're taking them out because there's a court order for them to come out, and they need to come out." But so that's the answer to your question. My client is ordered to take that 5 feet out, so you're taking it out. Okay. I'll take the 5 feet out, but it doesn't make any difference. It's not in the way of anything. So when I went over there to see, and he took the 5 feet out, and that's when I pulled the big SUV in there, and it's like, why? It doesn't. I could turn around that vehicle 4 times in that backyard. It's irrelevant. So as far as the spirit of the order is concerned, it was satisfied with the 15 feet, and now he's got to figure out what to do with that gate. But in any event, he complied with your order of last week.
Yeah.
Agree that he complied with the aspect of taking 10 slats, but it was my understanding.
Classic courtroom pivot. When you're losing on the law, shift to emotion. But here's the trap. Judges hate mixing property disputes with criminal accusations. It's like bringing a flamethrower to a chess match. Wrong battlefield.
And I was wrong that gate was attached to the 5 feet. I didn't realize it was a separate post. I did not know that, Your Honor.
All right, look. If what Mr. Smith says is correct, that he's looking to secure that back part of his property with the gate that's there, the grand reality is, if Mr. Smith is correct in that, is that he's going to move that post. He's going to somehow or another do something else with that gate. But it's the gate. From very beginning, I knew the gate was there. And I knew when the last time we were here that that post, that the hinge basically was there. And I knew, I'm looking at the photos from last time to see, just to even give some benefit of the doubt as to whether.
Bombshell self-correction. The judge admits, I was mistaken. I thought the gate was attached, 1311. This is rare judicial transparency. His original order assumed removing fence slats would remove the gate, but it was a separate post. Now he's trapped. Smith technically complied, 1135, but the intent failed. Watch his dilemma: order more demolition? Or concede his error? This is why property cases explode. One unclear phrase in an order creates years of fighting. The attorneys know they've got him cornered.
Not, I would believe that that was, just based on some distortion, that somehow or another, that post is somehow attached to the wood fence. I had I did not think it was attached, because it's not.
Okay, I was mistaken. I thought it was attached. And that would be an error on my part, Your Honor. But if he's going to move he intends to secure and move the post, that will be fine. If he leaves it there, and then what? If he puts up additional fencing from the post?
Okay, look.
I don't know what's going to happen.
Look. I issued an order. The parties were back. We went through painstakingly what needed to be removed of that wooden fence. Mr. Smith has complied with that. And so, because I still have jurisdiction over it.
The ruling lands, and it's a legal gut punch. Despite calling the gate harassment, 553, the judge declares Mr. Smith has complied, 1354. Why? Evidence over emotion. The SUV test proved access exists, and orders must be enforced as written. His message to Colani: file a new motion if you want the gate moved, 1402. Translation: you lost this round. Smith's thank you, 1412, drips with victory. But the war isn't over. This feud will be back in court.
If you really want to do it, then you file a motion, they can answer it, and I'll deal with it. But there's nothing before me right now. He did exactly what I asked him to do.
I will agree with that, Your Honor.
Thank you.
All right.
Thank you.
Why this case matters: 1. Precision wins. Smith's exact compliance trumped Colani's spirit of the law argument. 2. Evidence rules. The SUV demo destroyed Colani's access claims. 3. Stay on topic. Harassment allegations backfired spectacularly. The judge's hands were tied by the letter of his order, a harsh lesson in legal drafting. But the real loser? The neighborhood. These neighbors will keep fighting and billing attorneys hourly.
And here's the gut punch. The judge admits he misunderstood part of his own order. Rare, honest, but deadly for Colani's case. Judges don't like walking back rulings, but they'll protect the record. Translation: compliance wins, even if the order was clunky. Big takeaway: in court, the spirit of the law sounds noble, but the letter of the law decides who pays the lawyers. And spoiler alert, in neighborhood feuds like this, nobody really wins except the billing hours.